Welcome to everyone. We're going to be presenting a webinar this morning covering the topic of mediating franchise disputes. This webinar is presented and co-sponsored by Upchurch Watson White Max Mediation Group and also by the University of Florida Levin College of Law Institute for Dispute Resolution. Presenting today will be Ricardo Cata, and I'm Shelley Leinicke, and I will be serving as your moderator here. Ricardo has a background in mediating since 2013, and he focuses on commercial mediation, contractual and real estate disputes, franchise disputes, intellectual property disputes, and he also works with cases involving insurance coverage, professional liability, and personal injury disputes. Before that, he practiced for approximately 38 years and was involved in representing resorts and tour operators from Latin America, and also practiced in both Florida's circuit and federal courts. He has represented domestic and international manufacturers of products on claims of defect, and he has represented the United States and Latin American clients in both commercial and contractual disputes. Ricardo also worked approximately 2 years as counsel for Burger King on franchise matters. He is a native of Cuba, and he can mediate in both English and in Spanish. I'm Shelley Leinicke. I'm your moderator today. I focus on cases involving medical malpractice, product liability, nursing home liability, premises liability, insurance coverage disputes, and wrongful death. Before starting mediation, I served as the head of the appellate practice department at a large law firm. And while I was there, I handled appeals in all of the state appellate courts, of course, the Florida Supreme Court, and 3 appellate districts on the federal side. I had an active trial practice as well and provided a lot of trial support and assistance for my various partners. So that is who we are and why we are here. So I think at this point, Ricardo, we're ready for you to begin your program.
Thank you, Shelley. So again, good afternoon, everybody. My name is Ricardo Cata, and I'm going to be doing the presentation today on the topic of mediating franchise disputes, an area which is not usually, you don't see too many webinars in this area, but as I will talk in a moment about the growth of this area, I think it's an area that has disputes and growing disputes and should be paid attention to. Next slide, please. Okay, so we're going to cover franchising statistics. And the reason for this is going to be, again, to show how big and comprehensive this area is. As of 2018, more than 900,000 franchise establishments, there were more than 900,000 franchise establishments in the United States. Next slide, please. There were also an estimated of 3,000 different franchisors operating in the U.S., and it was estimated that more than 900,000 franchise businesses across over 300 business categories in the United States provide nearly 18 million jobs and generate over $42.1 trillion to the U.S. economy. As you can see, this is a big segment of the economy. Go ahead, next slide, please. About 1 out of 12 businesses in the United States is a franchise business. This could vary from different segments of the economy. As I will mention in a moment, restaurant business is the largest one, but it really permeates the whole economy. Next slide, please. Continuing with the statistics, according to the U.S. Census Bureau, franchises accounted for 10.5% of businesses with paid employees in the approximate 300 industries in which franchising data was collected from 2007. According to the International Franchise Association, the IFA, almost 4% of all small businesses in the United States are franchises, and it was estimated that the franchise industry accounts for approximately 50% of all retail sales in the United States, and further that a new franchise business opens every 8 minutes of every business day in the United States. Next slide, please. So as of 2017, 2 years ago, franchises, the breakdown of ownership were 71.9% men and 28% women. So the women have a significant, almost a third, but not quite, involvement in franchise ownership as of 2 years ago. That probably has grown by now. Next slide, please. The median pre-tax income for male franchisees averages about $73,000, and for female franchisees averages about $54,000. The average length of a franchise contract is around 10 years, and most franchise companies have fewer than 100 units. The median age of franchise owners is 45 to 54 years, and 44% of franchise owners have a bachelor's degree, with 19% holding an advanced degree, and 12% of franchisees are U.S. military veterans. 70% of franchise owners work an average of 40 to over 60 hours per week. Next slide, please. The ownership tenure for franchisees are less than 2 years, around 30%, 2 to 5 years, around 32%, 6 to 9 years are around 18%, and 10 years or more, 20%. So you can see that this varies from franchise to franchise. Okay, go ahead, next slide, please. Okay, the average initial investment for franchisees is around $520,000 across the 3,500 brands in 200 sectors. The most popular franchise sectors are quick service, lodging, business related, and the top franchise industry is fast food. Multi-unit operators control 54% of all franchise outlets, with 87.7 multi-unit operators being in just one brand. The International Franchise Association, in its 2018 Franchise Business Outlook, reflected a continued growth in the franchise industry for the 8th year in a row. So you can see that this is not only a large industry, but it is continuing to grow even larger. Go ahead, next slide. So now we're going to talk about the rise of franchisee disputes. Next slide, please. And this is the basis of this webinar. So as the industry grows, it is inevitable that with the growth rate, with the size of the industry that we just discussed, and the growth rate that has been taking place and is projected to increase, and the complexity of the franchise and nature of the franchise business, that no matter how hard the parties try to avoid disputes, there recently has been a noticeable rise in the number of franchisees. Next slide, yeah. So franchise agreements are usually lengthy, multi-pages documents, usually with attachments involving other areas. And they usually involve areas such as licensing, trademark, operational issues, real estate issues, zoning issues, quality control issues, marketing, royalties, distribution of products and so forth, vendors, relationship, intellectual property, and other issues. So you can see that the complexity of the document reflects the rights granted to the franchisee and the obligations of the franchisee to operate a business in compliance with the provisions of the franchise agreement, and vice versa. It also imposes obligations, not only rights, but also obligations on the other side, on the part of the franchisor, to comply with its obligations under the franchise agreement. And there is the point of sometimes where the disputes arises. Disputes can arise from many different areas. In some of the areas that I mentioned are some of the primary areas of dispute. but disputes can arise from things that happen even before the franchise agreement is signed. I will talk about a little bit later on disclosure requirements and areas of litigation that may arise from that. So even before there is an existing franchise agreement and an existing operating business, you could have areas that can be raised later on once a dispute or if a dispute arises between the parties. Next slide, please. Yeah, as I mentioned before, the increase in franchise disputes has been particularly noticeable in the restaurant sector because this is the largest one by far. And this is true not only in the United States, but also in Canada as well, which is very active also in the franchise industry. Next slide, please. So as the number of franchises within a given franchise system increased, almost naturally, so do the number of disputes related to a common issue or virtually all of the franchisees within that system. In other words, a dispute could arise as to one franchisee involving one issue, but oftentimes there are you have what's called system-wide disputes, which may start out with one franchisee, and later, if it's not resolved soon enough, and if it's not resolved specifically pre-suit or pre-arbitration, it could then grow throughout the system. So again, despite the earnest efforts on both sides, and I saw that when I was at Burger King many years ago, to avoid a dispute, there will come a time in the course of a franchise term that when the franchisor and the franchisee may not agree or may have different views about something, or the franchisee may feel that there were some misrepresentations made or some earning disclosures made that were not accurate, and I'm going to talk about that in a little bit, and there will be a dispute that may arise. I will talk a little bit further about that, but there are different areas of dispute resolution now that they weren't around when I was working for Burger King many years ago, and I'll touch upon that later. With the focus today, of course, being mediation. Next slide, please. So consequences of a drawn-out dispute. Well, this applies to any commercial dispute, of course, but the franchise industry, I think, in particular, because it's so exposed to the public, it's visible. It's a visible industry, and a lot of outlets, franchise outlets. A dispute can be very, very costly. It can create a lot of business disruptions, both to the franchisee and to the franchisor. So if you have a brand new franchisee, an all-out dispute where the franchisor could potentially put the franchisee out of business, and it also can be very disruptive to a franchisor. And if it's an upstart franchisor, it could also be significantly disruptive to that business and may even impede additional sales. It would generate bad publicity. And if it goes on to litigation or arbitration, it could result in dramatic business outcome for one side or the other, with potential significant damages and awards through litigation or arbitration. And depending on the franchise agreement, it could also involve attorney's fees and costs. It also involves usually a lot of experts. You have business experts on the actual food or whatever the industry may be, and you have accounting, and you have taxes, and you have real estate and all of that. So it can be very expensive. It could actually even lead to the destruction of the franchisee's business, as I mentioned before, and possibly the destruction of the franchisor's business if it is a new franchisor with recently starting the business. It could also, and this is very important, damage the system and its mark, especially in today's day where you have social media and all the different outlets for social media, and franchisees talk all the time, and they have meetings every year. They have meetings perhaps more than once a year, and they just talk to one another, so it can be very destructive to the mark. It also diverts a lot of the management attention as well as financial, marketing, operational resources from the growing and improving of the system. An adverse outcome or an unhappy or vocal franchisees, which they can be very vocal, can likely further aggravate the situation by making it difficult for the franchisor to sell additional franchises. Next, please. Okay, so here we go on the disclosure requirements, and it's going to be important not only from a legal point of view, but also as an incentive for early mediation. Next slide, please. So mandatory disclosures required under state and federal pre-sale franchise laws, and this goes to the point I touched before as to potential allegations when a dispute arises and litigation or arbitration arises. Under the U.S. Federal Trade Commission's trade regulation rule, disclosure requirements and prohibitions concerning franchising on the 16 CFR Part 436, the franchisor must disclose on the item 3 of his franchise disclosure certain civil actions and related settlements. Under this rule, an action includes complaints, cross-claims, counterclaims, and third-party complaints in a judicial action or proceedings, and they are equivalent in an administrative action or arbitration. So as you can see, the requirements for disclosure as to actions is pretty broad. Next slide, please. Moreover, and this is important, the disclosure requirements under the rule are not limited to actions commenced in the United States. For example, if you have a US-based franchisor and there's franchises in Canada, and there are disputes and litigation arbitrations in Canada, that will have to be disclosed as well, or in Europe or any place else. So that needs to be taken into account when considering whether to try to go to mediation early or not. Next slide, please. And this is the point. Item 3 of the disclosure rule does not require the disclosure of pre-suit settlements or disputes. So as you can see, this will be a significant incentive for a franchisor to try to resolve a merging dispute with a franchisee to the extent that it may be possible or feasible before it goes to arbitration litigation. The other thing, so this is a significant factor to try to have high-level, executive-level negotiations, and if that fails initially, and if that fails, then try to go to mediation before any action is commenced. And by the way, a lot of the more recent franchise agreements do have a tier level of dispute resolutions, usually starting with high-level executive discussions or negotiations, and then if that does not resolve the dispute, the next step will be mediation. Go ahead, please, next slide. On the other hand, that same requirement might discourage a franchisor from settling disputes after an action has been commenced if the mediation and the high-level negotiation did not work out, because then at that point he has to disclose it anyway. On the other hand, once the mediation, once the dispute goes into litigation, state or federal court, there will be another opportunity for mediation by court order. Of course, that will have to be reported if there's a resolution. So again, the favorite, I think the best way would be to try to have it mediation before arbitration or litigation. Also, many of the arbitration providers, arbitration services, do now provide in the rules a mediation option. They don't require mediation like in civil litigation. They don't order mediation, but they do have the option for the parties to go to mediation during the course of the arbitration. I have myself done several commercial mediations in pending arbitrations for the American Arbitration Association, and I've done one mediation in pending arbitration with the ICDR, the International Center of Dispute Resolution, which is a AAA branch for international. And I did that one 100% in Spanish because it involved Latin American parties and Florida parties that were fluent. Next slide, please. So let's talk about some of the most common areas of franchise disputes. Again, this is not going to be an exclusive list. Just some of the areas that I've seen most recently when I've done franchise mediations, and also when I was back in Burger King. Next slide, please. So they usually involve breach of contract, the contract being, of course, the franchise agreement, fraud and misrepresentation claims, breach of implied covenant of good faith and fair dealing, violation of applicable federal and state franchise laws. These are the 4 areas and their subdivisions that you see, that I have seen when I have dealt with franchise mediations, and also way back when I was with Burger King. Next slide, please. So, fraud and misrepresentation, one of the areas that can be included under that, as I mentioned earlier, it arises from even before the franchise document is signed. Some franchisees claim include misleading earning claims in their actions against franchisors. You see this often, and some franchisors do include earnings representations in disclosure documents given to the prospective franchisee, the Uniform Franchise Offering Circular, or UFOC. By the way, this disclosure document must be provided to a prospective franchisee at least 14 days prior to the prospective franchisee signing any agreement related to the franchise. So you can see how this could be something that happened before the franchise agreement is signed, but could result in a claim later on. So if a franchisor, suggestion, if a franchisor decides to include an earning claim, it should follow the North American Securities Administration Association NASAA format and guidelines, which have been approved by the FTC and by various state agencies, and pertain to the type and the nature of the earnings information that can be included in the disclosure document. This is important. Next slide, please. So I'm only going to be touching here upon the areas of claims. I'm not going to go into the legal aspect of that. That would be beyond the scope of this webinar, because the main focus here is mediation. But these are the areas that usually show up. Encroachment claims. This is another area that I've seen often, and this involves territorial rights, which often occur between the franchisor and the franchisee due to a franchisor's expansion of the franchise system. Some franchisees or many franchise agreements contain clauses allowing the franchisor to expand the system, and on the plain reading of the clause, it will appear that that there is no exclusive territory allowed to the franchisee. In other words, it will preclude a claim to exclusive territory. However, significant disputes and litigation have resulted over this topic, and I will mention later on the case of Sheck versus Burger King. I'm not going to discuss that case in detail, but that is one of the leading cases in that area, arising initially out of the Southern District of Florida, but there have been several other progeny from that case. But it all revolves around this issue of encroachment claims and the franchisees claiming that the franchisor opened another competing restaurant with the same brand within the franchisee's area of the market area. Next slide, please. And of course, that would, the claim is that would cut down the profits and the business of the franchisee. Non-compete clauses. This is another area that you see often, and most franchise agreements have non-compete clauses as to the franchisees, both during the term, quote, in term, close quote, and after the termination of the franchise agreement, post-term. Some states may impose and have imposed limitation on the enforceability of these clauses. This is one area of dispute. For example, California on the section 16600, etc. of the California Business and Professional Code have imposed some limitation between and specifically as to the distinction between interim and post-term covenant. That may be an important legal distinction under this statute and related case law, and should be looked at and considered by prospective franchisees, and also when a dispute arises and these claims may be made, depending on what state the franchisee may be located. Next slide, please. Okay, forum selection clauses, another area. Oftentimes, a franchisor in the franchise agreement will specify a particular forum or judicial or arbitral forum or particular geographical area for any dispute to be resolved. Oftentimes, those have been construed or seen favoring the franchisor, either as to the particular forum or the geographic area, and being negative to the franchisee because it may be costly for the franchisee to travel, for example, to Miami or some other location to litigate against the franchisor or to arbitrate against the franchisor. So this have also generated litigation and claims as well. And this will be probably before pre-suit or early litigation claim issue that will have to be resolved before the case goes forward. Next slide, please. So now we're going to talk about increased use of mediation in franchise dispute. Next slide, please. So most franchisors and franchisees will agree that an all-out litigation or arbitration battle between a franchisee and a franchisor is basically a no-win situation, mostly for either side. Usually the one that suffers most is the franchisee, because the franchisee, unless it's a multi-unit operator with many franchises, if it's a one or two unit operator, they don't have the power, the leverage, the sustaining capability to undertake an all-out litigation. But it could also be very damaging as well for the franchisor for the reasons I mentioned earlier: bad publicity, damage to the brand and the mark, and also potentially eliminating any possibility of maintaining that business relationship that has been developed. Most of the time has already been developed and been going on for a while. Next slide, please. So the other reason for the growth of franchise mediation is that the reported literature is that it has worked. It has yielded good results. For example, the franchise mediation program operated in conjunction with the International Institute for Conflict Prevention and Resolution, known as CPR, has reported that since its inception in 1994, the program had achieved a success rate of approximately 80%, which is amazing, I think, in mediations in which the franchisee agreed to participate. Likewise, settlement rates in franchise mediations ranging from 65 to 80% have also been reported by other mediation services. And I think the reason for this is that, for reasons that we have talked already, there is a lot of incentive on both sides most of the time to try to resolve a dispute and save the relationship, and try to do it earlier on before it grows out of control. Next slide, please. So what are the benefits of mediation? This is true for franchising, but it's also true for any other commercial mediation. It reduces legal costs. As I alluded earlier, franchises and franchise relationships are very complex. They involve many different areas, and in an all-out litigation or arbitration, they will be costly not only because of legal costs, and if you have a three arbitrator panel, the cost can be even more significant. And then you have the legal costs involved in prosecuting or defending the claim, and also the cost of experts that would need to be involved in the dispute. It also reduces the risk of litigation if it's done pre-suit, and also reduces the risk of ongoing litigation if it's done even after the litigation has commenced. It also reduces the operational and business disruptions of a drawn-out litigation. I mentioned that already. This takes a lot of attention from the day-to-day operation. The franchisor and his or her store manager or whatever the manager may be involved will have to spend a lot of time addressing the dispute, if it's in suit, given deposition, producing documents, and all of this takes away from the business, and it reduces the operation on the businesses and increases the operational and business disruption related to litigation, or decreases it, I should say. And the other thing is very important. It often preserves an existing business relationship between the parties that has been going on for quite a while. Next slide, please. Mediation is also much faster. Mediation can usually be scheduled within a matter of 2 or 3 weeks or a month, depending on where the parties are and the schedules. And it can also usually be concluded in 1 day, perhaps even less than a day. Sometimes it can go into a day and a half, but still much sooner than litigation. And that even includes the preparation time before the mediation. It's still much faster. The other thing about mediation is that it's very flexible. The parties can draft an agreement of their choosing. They can decide what terms, what conditions, what scheduling of implementation of the agreement they're gonna decide upon and agree upon. And they don't have to designate a winner or a loser, or who was right or who was wrong, which is very important, especially if one is trying to solve an existing business relationship. Next slide, please. Usually, most of the time, I've had mediations where I brought an expert to a mediation, but that's very, very unusual. And that was a very specific type of case. There are no witnesses. The parties relied on whatever discovery may have been done, either by disclosure of documents or other means. There's no discovery per se during mediation. Expert fees, no expert fees, although I'm going to talk about a little bit later that sometimes one side or the other, especially the franchisee, may have on call a tax consultant, for example, if in the case that an agreement may be made, but you don't have to have that person there at the mediation. And there are other costs and delays associated with litigation or arbitration, which can be quite significant, would all be eliminated. Next slide, please. According to the CPR Institute for Dispute Resolution, they have estimated annual savings from using franchise mediation of $25 million for their members who have participated in franchise mediations with their franchisees, which is quite significant. Next slide, please. So even when a mediation, quote, fails, close quote, I don't really believe that a mediation ever fails, even if there is no agreement at the end of the mediation. But even if it fails, if a settlement is not agreed upon at the end of the mediation, the mediation process, at a minimum, usually and likely will provide each party with a significant view of their own and the opposing party's case. And when I said their own, because when you prepare for mediation, you really have to go through the whole case and familiarize yourself with all the issues all over again. Even if you've been litigating the case, you review everything and you start focusing more on what the strengths and the weaknesses are. It will also give the parties an opportunity for an early evaluation of the factual and legal weaknesses and strength of their own case and of the opposing party's case, including as to damages and liabilities, perhaps even the witnesses that they may have or may not have, and analyze their best and their worst alternative to a negotiated agreement, what's known as the bad net and the what net. So I don't think a mediation is ever a waste of time, as long as the parties are both sides involved in good faith, which is an abused phrase, but they're both there trying to resolve the case, prepared to mediate, and willing to try to resolve the dispute. Next slide, please. So a lot of the franchise agreements, I mentioned this earlier, contain an early resolution provision. The use of mediation has become much more prevalent as a result of this component of the dispute resolution clause. Some major franchises have also agreed to mediate their franchise with their franchisees pre-litigation or pre-arbitration all disputes which are not resolved through high-level negotiations as part of the National Franchise Mediation Program. Next slide, please. Next slide, please. Okay. The mediation is a good process to resolve the franchise dispute because the franchisor and the franchisees have, not often, but usually have been involved in a business relationship, sometimes for years, sometimes for quite a while before the dispute arises. So they know each other, they know their regional people, they know the marketing people. So it's a lot of relationship that's been going on already. They have invested a significant amount of time in that relationship, as well as significant amount of human resources, funds, marketing, training, and operational resources. Most franchisors require new franchisees to go to a training session, a university, so to speak, on that particular brand and product. So there's been a lot of relationship developed. They've been usually engaged in direct negotiations efforts before the dispute erupts into litigation at high level, executive level. So another reason that this may be a good setting for a mediation. So both sides are already well informed as to the nature and issues of the dispute. Next slide, please. Unlike litigation or arbitration, which is usually adversarial and adjudicatory and is focused on finding who's right and who's wrong, who's going to win, who's going to lose, mediation addresses each party's interests. The parties are free to shape their creative solutions, ideas, terms, conditions, alternative avenues for a resolution and monetary solutions. This is not available in arbitration litigation. Minimizing the payments under a settlement by being creative in how to structure it for tax purposes. This is one area where they may want to have a tax consultant on call. Deciding the manner and the timing of the payments, given the protection of confidentiality at the mediation. And of course, the outcome of the mediation is also confidential, which is not the case, certainly not in litigation. Minimizing the investment of executive time and even high mid-level and executive time, and reducing potential for adverse publicity, which it can be very important to the franchise brand. Next slide, please. And it's also, there's also feedback that mediation is favored by franchisees and franchisors. For example, in 2015, there was a survey done by franchisegrand.com. They did an expert survey, and they asked the question, when reviewing alternative dispute resolution clauses, what do you feel is the most reasonable structure for a balanced relationship? More than 50% answer that mediation followed by arbitration best supported such a relationship. And 66% in that survey responded that they believe that mediation prior to the commencement of any type of legal action was the best path forward for the franchisor and its franchisee. Next slide, please. So when there is a resolution through mediation, the franchisor is under no obligation to disclose the dispute or the outcome of the franchise disclosure in the franchise disclosure document. So this is very important. And it can also keep, and this is also important in the franchise setting, it can also keep a conflict with one franchisee or one multi-unit franchisee from metastasizing throughout the franchise system, potentially inhibiting the success of the brand and the sales of additional franchises. Next slide, please. So I'm going to talk about some of the disputes that may not be suitable or less suitable, and I'm not saying that they cannot absolutely be mediated, but often you don't see those go into mediation, or mediations may not be successful. Next slide, please. The first one is when an unwaiving or non-negotiable principle of the franchisor, and this happens, with a system-wide ramification may be at stake. It becomes very difficult for the franchisor to mediate that, especially mediated pre-suit, or even after pre-suit when you have to report it, it becomes even more difficult. The ideal thing would be to try to resolve this pre-suit, that type of dispute, but it depends on the nature and how important it would be for the franchisor. One party desires an opportunity to establish new case law or defeat an existing adverse case law, such as the Scheck versus Burger King cases and the progenies from that, which involve claims of territorial encroachment. That may be a situation where mediation may not work, and the fact that there have been several other court decisions after that case, including appellate court decision, shows that there is interest, for example, in that situation, of not resolving the dispute and going into a judgment and then appeal. If the terminated franchisee continues to use the trademark without consent or payment, in that case, most likely the franchisor will immediately seek injunctive release in state or federal court. Next slide, please. If there are confidentiality restrictions in the franchise agreement or the operating manual that are being violated by the franchisee, even after they have been put on legal notice not to stop, that may also not be something that the franchisor may want to mediate, but they may want to go to court right away. If several franchisees are involved or the dispute relates to issues of contention throughout the franchise system, that would put greater limitation on the franchisor to negotiate its position and the flexibility as to a negotiated agreement. Again, I'm not saying that these areas cannot be or should not be mediated, but they're more difficult to mediate. And the last one, not the last one, but the last one on this list is if there's an emergent issue related to public health, for example, food or contamination, etc., associated with the franchise operation. Usually that is dealt with right away. Next slide, please. So components of a successful mediation. Next slide. This will apply to any mediation, but we're talking here specifically about franchise mediation. Both parties be willing to negotiate in good faith with an open-minded approach to finding a solution and to finding a compromise. This is very important. As I mentioned earlier, just before, about the areas that may not be suitable for mediation. If one area is absolutely anchored on not moving, it becomes very hard to really resolve the mediation. And I'm not even talking about good reason for not trying to resolve the case of mediation, but then it becomes very difficult. Both areas have to have a sincere interest in working hard and finding a mutually acceptable path to a resolution. They have to be invested in the resolution of equally invested, or at least as equally as possible in trying to find a resolution. That doesn't mean that both sides are going to be equally happy or unhappy, but that they want to try to find a resolution. Be willing to stay involved and focus on finding the path without concerns of catching a flight. This happens, believe it or not, from time to time, or being bound by whatever time was originally reserved. And the mediator, I know that I do this. When I have a mediation like this, I am willing to stay, and I will stay as long as it takes. Next slide, please. Yeah, this, I mentioned that before. Try to stay away from both sides, from being anchored from the outset to perhaps an unreasonable position. Try to be open-minded and willing to negotiate towards a compromise. Next slide, please. Yeah, mediation in general, and specifically in franchise, the greatest chance of success when both parties do not have, neither party has the luxury of being able to walk away from the mediation without an agreement. Both sides need to be equally invested in the outcome of the mediation and in trying to negotiate a resolution to the dispute on mediation, no matter how long it takes. Next slide. I always ask for this several days, perhaps even a week before the mediation or so. Both parties, or even more than a week, should submit their respective written positions with the key relevant pleadings or documents to the mediator, either on a confidential basis or if agreed by the parties, share with both parties. This goes a long ways, not only to educating the mediator as to the issues, but also in getting everybody better prepared to start having a productive mediation right from the beginning of the session. It also allows the mediator to become much more informed in the nature and the detail of the dispute and the specific claims and defenses of the dispute and the legal issues being raised and factual issues before the conference, way before the conference. And also will help the mediator to have pre-mediation conversations with both sides and allow the mediator to begin developing thoughts, ideas, strategies, and inquiries as to potential areas of agreement and suggestions as to any areas of disagreements that are presented. Next slide, please. The more information that and key documents that better prepare that both sides are, and the mediator is, and before the mediation, the better prepare both sides and the mediator will be for the various directions that the mediation, especially the franchise mediation, which has so many moving parts, is likely to take in order to be resolved. So preparation is key. And information is key, and also the mediator talking to both sides, and both sides would be willing to talk about the mediator, not only about the factual and legal issues, but also process issues. For example, I touched upon who's going to be there, what's the level of authority of the person or persons who are going to be on either side. Are they going to be rushed to leave early? Is there any particular issues that may be involved from a personality point of view, from a legal or factual point of view? All these things need to be explored before the mediation. They will also be explored during the mediation, some of these areas, but it's better to explore them as much as possible before the mediation to make the mediation more productive. Next slide, please. Yeah, I mentioned this earlier. You don't need to have these people present, and I never see this present, but I have seen it in caucus, especially when particular legal issues, not legal issues, operational issues or tax issues or financial issues arise. One side or the other may have a consultant, let's call it, not an expert, but a consultant available on the phone on tax issues, especially if a settlement agreement is getting close and there may be terms that may affect tax and may have tax ramifications, or leasing issues or real estate issues. So you may have they may want to have somebody available, a consultant, to discuss that and facilitate a resolution or make it more easy to resolve the case on that day, which is important to have a resolve that day. Next slide, please. Yeah, mediations are most likely, and again, this is not only franchise, but particularly franchise, produce an agreement with everybody. All stakeholders are either present. I think the principals need to be present, and perhaps a stakeholder that is not directly a principal but has significant interest may also need to be available by phone. In most court and arbitration rules, this is required. And in my opinion and in my experience, if all decision makers are not present, it is very difficult and at times impossible to reach an agreement. This is why if a key decision maker has to leave early to catch a plane, when things are beginning to really gel after 5, 6, 7 hours, it's very difficult for that person to maintain state engaged and focused while he or she is going through the security line at the airport. So it's important to be present and stay present until the mediation is over. Likewise, any guarantor of the franchisee's obligation or a spouse, the spouse may not be a signatory to the agreement, but the spouse may be very, very much involved in the operation and the financial ramifications of any agreement. They should also be the present or definitely very much available during the mediation. Next slide, please. The mediator's skill and experience are very valuable, obviously, to both sides. In not only in the knowledge of the subject matter, but also the process and mediation skill for breaking a potential impasse, keeping the mediation going, suggesting alternative areas of resolution, so alternative ideas, raising risk factors, and being very creative in his or her thinking and thinking outside the box to keep the process going, and perhaps raising issues that had not been considered previously by either side. Next slide, please. So selecting the right mediator is very important in general, but also in franchising, because as I mentioned, franchising is a complex area. It's not just one area, but it has multiple areas of subject matter, if you will. So the mediator selected should not only be good at the process of mediation and have a good experience and skills of mediation and breaking impasse and so forth, but also understand franchising and the complex dynamics and intricacies of a franchise relationship and the legal issues involved in the dispute. For example, the reporting and so forth, that may be a factor during the mediation if it's not resolved, and also willing to keep the parties talking and keep negotiating as long as it takes, and trying to find common ground. Next slide, please. The mediator should review the pre-mediation submission, familiarize himself or herself with the issues, then reach out to both sides separately initially, and if there are issues that develop during the separate conversations, have a conference call with the lawyers to try to iron out any process issues, any logistical issues, any personalities issues before the mediation starts. And also through this process, the mediator should already start developing thoughts and ideas and a path towards a resolution or a potential resolution of the subject dispute or disputes before the mediation starts, and also, of course, during the mediation as well. The mediator needs to be a very good listener. That's one of the key skills of a good mediator, a key listener, and also a good communicator. Listening is very important, and help the parties communicate then and narrow their disputes, and with the objective always to try to bring the parties together and obtain a resolution. Next slide, please. Yeah, and I've seen this where it gets late. I was in a mediation recently that we were there until 10 o'clock, 10:30 at night actually. Everybody was gone. The cleaning crew was cleaning the office. But I felt, and the parties also felt, that it was important to keep going and to get it done that night. And it got done, and it was very, very good that everybody stayed there. The key, though, if it gets done, if it doesn't get done, the danger is that the next day, even if they were very close and there was something within reach, if the parties go back and they talk to their spouses or to the stakeholders or to the CFO, CEO, or COO of the franchisor or the multi-unit franchisee, that deal that was very close, within reach the night before, may no longer be available. So that's important to keep in mind. The other thing is if a settlement is not actually reached during the mediation, but a lot of progress has been made, the mediator should, and I always do, stay engaged and in contact with both parties as long as necessary, as long as it takes, to assist the parties to continue building upon the progress and the process to try to come to an ultimate resolution. Next slide, please. This is something that I always suggest for both sides to bring a template of an agreement, settlement agreement, and then they can fill in the blanks. So the goal here is to try to get it done that night, fill in the blank, have an agreement done that night, and not to litigate the terms of an agreement later on. You want to avoid that. Yeah, you don't want to have a post-mediation fight over the terms of the agreement that was reached during mediation. Next, please. Also, again, on the same topic, if an agreement is reached, even if it's late, the parties need to stay there, and the mediation needs to make sure that this happens as long as it takes to get it documented and to get it signed by both sides. Otherwise, under most rules of mediation, if there was no signed agreement on that day when the mediation was concluded, then there is no agreement. Thank you very much. Shelley?
Yes, good. Thank you very much, Ricardo, and thank you to all of our attendees today. If you are a Florida lawyer, will you please jot down the Florida Bar course numbers so that you can post your CLE credit online. The Florida Bar code number is 190335-2N as in Nancy. Let me give you that number again. It's 190335-2N. Upchurch Watson White Max also has offices and mediators in Alabama, so we do have CLEs there as well. If you're an Alabama attorney, we'll report your attendance to the MCLE Commission based on the information you gave us in a survey that was sent with our follow-up email, or that will be coming in on Friday. We're also going to be presenting another webinar on December 11, which is called Negotiate Like a Pro, Professionalism Matters. In addition to that, we're building our webinar schedule for next year for 2020, so please watch your email inbox for news about our future programs, and contact information for us regarding this program today or future programs is available on this final slide here that's on your screen. And again, thank you, everyone. We very much appreciate your attendance at this webinar today.
Thank you, Shelley.